Mr. Clement, your understanding of for cause, you went through hypotheticals with Justice Alito about how it doesn't cover pre-office conduct. What about conduct in office that doesn't relate to the discharge of the office? Like, what if you take some of Justice Alito's examples, but it's like Nazi videos while the governor is in office, or things that would be misdemeanors rather than infamous crimes like shoplifting, stealing things, domestic abuse. Would those things be cause for firing, or they don't really seem like impeachable offenses necessarily?
So I don't think those would be removable offenses under INM.
Okay.
And so I don't think they would be removable offenses under for cause properly construed.
So there's nothing that the president can do to get rid of someone who does those kinds of things while in office?
So, I mean, some of the things we're talking about, seem like better grounds for like an intervention than for removal.
I could come up with others, but.
Absolutely.
But sorry, keep going.
I'm going to fall back on my answer, which is that's my understanding, and I think it's actually everybody's understanding of how INM works.
But it doesn't say INM, and so I appreciate your argument that INM and for cause are one and the same, but you also kind of pull in your fallback some sort of like gerrymandered things like infamous crimes, but you don't have to have a conviction. So it doesn't say INM.
So a couple of things. One is, I'd resist, gerrymandering's generally not a compliment. So I would sort of say that what we do is we bring in the common law. And that's what we do. And I really didn't try to gerrymander it beyond that. But let me make the argument, which I really...
Can I just ask one clarifying question? I thought the common law, though, required conviction.
It did, and that would be our sort of frontline backup position, if you will. But the happy thing for me, I think, is at this stage of the case, we win under all these variations, and ultimately, some court, and it may be this court, is going to ultimately say these are the metes and bounds of for cause. Now, I think I have some pretty good arguments that it really is just INM plus ineligibility as kind of informed by Section 244. And let me just give you my best shot at it, which is this is the very unusual situation where we know that Congress was literally waiting for this court's Humphreys executor decision. And then it gets Humphreys executor's decision, and this court in Humphreys executor at least 3 times uses for cause and INM interchangeably. And then the senators themselves in the debate, now you got to look at debate, but I think even Justice Scalia looks at debates for original public meaning. The senators in the debate use the terms absolutely interchangeably. And so you have 2 of the 3 branches of government, original public meaning, saying for cause, different words, but what it means is INM. But I do think it must, you got to make sense of Section 244 of the statute, which does provide a very specific eligibility requirement. And as I said before, I think if some Fed governor was insisting that they also wanted to be a director at Chase National, they could be removed for cause for that.
Okay.